It's Monday, it's the 9th May 2022. And last week I read the statement of Joan Morris, mother of Dee John Reid, the victim impact statement that was read to the court. And I did promise that I would read out the sentencing remarks, because over the weekend many people were giving their own theories and they weren't in court. And I think it's important that we tell you what the judge had to say. Now, there are parts in this where people are named which I'd rather not call out names. I will refer to them as either adults, significant adults, and I will not be naming the young man either. And there is a part that talks about a parenting order, which I will not read that part out either. But you will get the gist of it. But the other parts I will read. So therefore, the Mr. Justice Johnson, these are his sentencing remarks from that were read out last Friday. That's the 6th of May at Birmingham Crown Court, and his sentencing remarks began at 12:15. And it reads, on the 31st of May last year, you killed Dee John Reid. He was just 14. You had armed yourself with a knife. You chased him. You stabbed him to the chest with that knife, penetrating his heart. He stood no chance. He was unarmed. He was no threat to you. The jury rejected your account of self-defense. They convicted you of manslaughter. All cases of unlawful killing involve the worst harm possible, the loss of a human life. Dee John was a child. He was much loved by his family, including his mother, Joan Morris. He was a son, a brother, an uncle, a nephew, a cousin, and a friend. His mother's victim impact statement, which was read to the court, shows just how loved he was. She describes him as a handsome son, bouncing around with life, a budding footballer with aspirations to become a footballer or a dentist. He will never be able to do those things. She will never see him pursue those ambitions or become engaged or a parent or to have his own home. She's not even able to have a conversation with him face to face. This is because of what you did. On that day you were out with your friends. You came across Dee John and his friends. There was some form of confrontation. The prosecution accepted that there was an attempt to mug one of your friends. At that point, you ran away. Later, you were in a shop when again there was some form of confrontation with one of your friends being forced to buy some drinks. But whatever was done by the other group of boys, it did not remotely justify or excuse what happened next. A significant adult, together with his friend, came and collected you and the other two boys. You had picked up a large kitchen knife and hid it in your tracksuit bottoms. The significant adult drove around the local area looking for Dee John's group. When he found them, he shouted disgusting racial abuse. He parked up. You all got out of the car and chased down Dee John. You had put on a full-face balaclava and had put up the hood of your top. You were wearing gloves. The significant adult told you to bang him out. It looked like he was getting away. He was faster than you, but he had asthma, and he ran out of breath and stopped. You walked up to him and stabbed him, then ran away. Within moments, Dee John collapsed and died. In deciding how to sentence you, I have to apply the law set by Parliament. I have to follow the guidelines provided by the Sentencing Council. First, I have to decide how much you were to blame for what you did. Some cases involve a low level of blame. Some involve a medium level of blame. Your case, however, has factors that show a high level of blame. This is because you stabbed Dee John with a knife to the chest. That carried a high risk of death or really serious injury. Even though you were 14, that was or ought to have been obvious to you. It is also because I am sure that you intend to seriously hurt Dee John, even though the jury's findings you did not intend to cause really serious bodily harm. The guidelines provide that in such a case, the starting point for an adult would be a prison sentence of 12 years. There are points to make what you did even more serious. First, you had taken a kitchen knife to the scene, together with a balaclava and gloves. You had planned to commit an offence. Second, this was an offence which involved others in which you took a leading role. Your co-defendants were acquitted by the jury of homicide, but that does not mean they had no involvement in what you did. The CCTV shows that there was a concerted chase of Dee John, which led by you and which involved 4 others. Third, you attempted to conceal evidence of your crime by disposing of the knives and gloves. Fourth, the offending took place in broad daylight in a busy public place. The shock and distress of those who saw it is clear from the CCTV and the evidence that was given. There are some points in your favour which reduce the sentence. You have no previous convictions. Although you pleaded not guilty, you have always accepted responsibility for the actions that led to Dee John's death, and you have expressed clear and genuine remorse for Dee John's death. You cannot understand the unimaginable grief that his family are suffering and the extent of the impact on them of Dee John's loss. But I accept that you have shown some limited understanding of that. I agree and accept with the submission of your barrister, Mr. Clark QC, that the conduct of a significant adult was an extreme and negative influence on you. He drove you to the scene. He used terrible racist language. He assaulted Dee John by throwing his keys at him. And he shouted at you, "Bang him out." If it were not for this significant adult's conduct, you would not have confronted Dee John on College Road. This significant adult's contact is a very significant factor in this case. Your barristers say that you were provoked by what had happened earlier in the day, but whatever had happened earlier was over. You were safe and well away from the scene. There was no need for you to go after Dee John. The earlier events provided a motive, but they did not amount to immediate provocation. The factors that increase your blame outweigh those on the other side. If an adult did what you did, then that would almost be certainly murder, and they would be sentenced to life imprisonment. But if an adult committed manslaughter in equivalent circumstances, then I would impose a sentence following trial of 15 years in prison. You are not an adult. You were just 14 at the time of the offence. You had not been taken to school for 2 years before the offence. The most powerful points in your favour are your age, your immaturity, and the overbearing influence of the adults around you. The guidelines require that I apply significant reduction to the sentence that would be appropriate for an adult. The reduction may be 1/2 for an offender who is 15 and more for a younger and more emotionally immature child. Because you are a child, the law says I have to think about what is best for you and how to help you stop from committing more crimes. I have to focus on you as opposed to the offence you committed. I must have regard to the effect that the sentence I will pass is likely to have on you, as well as the underlying factors that contributed to your offending behaviour. The guideline says that custodial sentences can only be a last resort. They are particularly rare for a 14-year-old child. I can only impose a custodial sentence where an offence is so serious that no other sanction is appropriate. This offence took place in the context of a very particular set of circumstances. including the bad influence of a significant adult. I do not think you are a significant risk to the public from the commission of further specified offences. But you took Dee John's life. The offence is so serious that I have to impose a custodial sentence. The secure unit where you are currently detained provides education opportunities and also opportunities which are designed to reduce the risk that you will commit further offences in the future. There are signs that you are engaging in those activities. I am satisfied that a custodial sentence is necessary, but the regime where you will be detained provides the best prospect for rehabilitation. I therefore pass a sentence of long-term detention under Section 250 of the Sentencing Act. I make a deprivation order in respect of the knife. I make a parenting order in respect of the adults concerned. I impose a statutory victim charge in the sum of £34 or such other sum as is required by statute. I sentence you to an order of detention for 6 years and 6 months. You will spend half of that time in custody. After you leave, you will have to follow the rules you will be given until the end of the 6 years, 6 months. If you break any of those rules, you may have to go back to custody for the rest of your sentence or for some of it. This is the sentence remarks made by Mr. Justice Johnson at sentencing last Friday, the 6th of May, in Court 4 at Birmingham Crown Court. And one thing I just need to hastenly add, we have removed names from this sentencing in order to do the right thing as asked by the court, in order not to reveal the identity of the young man who was sentenced for the killing of Dee John Reid.